Now at this time, I want to throw the floor over to Legislator Connie Barker.
Thank you, Chair. At this time, I would like to introduce our next speaker. Our first presentation will be delivered by Mr. Stephen Greetham, Special Counsel for the Chickasaw Nation, on the topic of strengthening our relationship, tribal sovereignty, the government-to-government dynamic, and effective public collaboration with tribal nations. You can find Mr. Greetham's full bio in our meeting packet via the file transfer protocol site provided in the email logistics. Without further ado, I am honored to introduce Mr. Greetham, who represents the Chickasaw Nation, but comes from all over the United States. Right now, he's located in North Carolina, just leaving the great state of Oklahoma, but I'm happy he agreed to be here today to share his expertise on government-to-government relations. Thank you.
Thank you very much. And thank you for the invitation to come and visit with you. I do feel like I need to raise my hand and swear an oath in this setting. My comments are going to aim a bit more toward the conversational. And I certainly invite the actual tribal leaders in this room to chime in and correct or use the Q&A to expand at any point that's appropriate. I ought to start my thing. There we go. All right. So I'm Steve Greetham. I am not Native. I am a New Englander raised by Canadians who went to law school to do environmental law and got bored to tears. And through my own studies, kind of came across, like Columbus, discovered Indian law. And it spoke to me in a way that other topics in law school simply didn't. The complexity of the issue, the histories that were involved, the humanity that was involved, pretty much every justice issue that comes up in the law plays out within federal Indian law in a fascinating and very compelling way. I ended up, I've worked for 25 years as a lawyer, only for tribal governments and only in Indian country. And in making that point, I want to emphasize, tribes and Indians are not the same thing. As a lawyer, I represent tribal governments. I represent the institutions where the tribal sovereignty is housed and exercised. And I work with tribal leaders who are among some of the hardest working people I've ever encountered. Some of us were talking about this at lunch. I am generally in awe of the amount that tribal leaders have on their plates. And when I sit in a meeting like this, and the acronyms alone kind of leave me in the dust, and I think about all the different topics that folks have to engage in on behalf of their tribal community to represent and to carry that information back to the community and leaderships. It's an awesome responsibility. So it is, I think it's an honor to CDC that you all are doing this, and you're doing it without any compensation, but just out of your commitment to your tribal communities. So I think that's amazing. In my presentation here, I'm going to speak as a lawyer and as a non-native lawyer, and as a non-native lawyer who's worked in New Mexico and Oklahoma. So people talk a lot about the diversity within Indian country, and that's a very true thing. There are 38 federally recognized tribes in Oklahoma alone. So when you talk about that government to government relationship, it takes a different flavor depending on which tribe you're working with. And there's over 570 tribes. So my experience is going to necessarily be narrow, but my goal is to provide kind of a useful overview of the law, starting with some critical history and starting with some local history here in Atlanta. And I think it's an important conversation to have in a place like Atlanta, and I'll get into that. I'm also going to talk about, I'm going to probably talk about tribal sovereignty less in terms of the legal doctrines, but more as it's relevant to talk about the government-to-government relationship, and particularly the relationship between federal government institutions and public health and tribal populations, and give some examples, both bad and good, on that. So without further ado, my wife, who I like to refer to as my better three quarters, long ago, she transcended being my better half, but she is a Chickasaw woman. She is a Native historian and scholar. And she teaches a lot of history. And one of the more compelling points I think she makes when she talks to her students is 100 years really is not that long a period of time. Her great aunt Hattie, who passed away just a couple of years ago, was born in Indian Territory prior to Oklahoma statehood and lived well into the 21st century. She lived to be 105. And I think anyone, it's worthwhile to go through an exercise of think of the oldest person you've ever personally known and think about what the world was like when they were younger. And then think about who is the oldest person they likely knew. And it really only takes a couple of people and you've just traveled 200-300 years back in time. And in my experience, tribal communities are storytelling communities. And the stories that are told in community gatherings around dinner tables are often those histories. And it's those stories that kind of provide a glue for the community to hang together. So we're here in Atlanta, in the state of Georgia. And just a couple hundred years ago, this was a rather violent location when it comes to Native nations. This map shows you the Aboriginal territories for Seminole Creek, Choctaw, Chickasaw, Cherokee, Quapaw, Osage, and the Illinois Confederacy. And you can see that swath of color in between the colonial presence that was expanding throughout the United States. 5 of these tribes, the so-called 5 civilized tribes, were at the heart of Andrew Jackson's removal policies. When I was preparing to come out here, I looked up just on a hunch, and the city of Atlanta was founded in 1827. That was the same year that the Chickasaw Nation signed its removal treaty. That was in the middle of the coercive removal of Creek and Cherokee people from their Aboriginal homelands. And Atlanta is not kind of one of those grand dam cities of the South like Savannah or Charleston. It was a beachhead that was founded right here on the boundary of Creek and Cherokee nations. So as the native populations were forcefully expelled from the eastern half of the country, the state of Georgia was well positioned to exploit those lands, to expand the practice of enslaving human beings for labor, and to use stolen land in violation of treaty and otherwise. It was a coercive act. And the act of removal to physically, like to ethnically cleanse an entire sweeping landscape, it's hard to overstate the trauma that causes. What happens when you have a wholesale relocation of populations? I think the CDC, some folks might have some good insights on that, but you lose your most vulnerable populations, your elders and your youth, your past and your future. And this happened to each of these nations, stripped from their Aboriginal homelands and forcibly relocated. Let's talk about kind of what was going on in the buildup to that. In the early 1800s, the Creek Wars were fought along the Alabama-Georgia border. And that was a military resistance to what was presumed to be the coming removal and the continuing expansion of non-native populations. Other side of the coin, War of 1812. The Chickasaw and Choctaw nations were fundamental to the United States victory in the War of 1812. The United States Army had to travel across the Chickasaw and Choctaw nations to get to New Orleans to fight in the Battle of New Orleans, which was a pivotal battle that ultimately meant that the U.S. won that war and repelled Britain. Meanwhile, in Florida, there were the Seminole Wars started in the early part of the 1800s and extended into the 1860s. When we talk about government to government, honestly, all of these are an example of a government to government relationship. War is a government to government relationship. It's as between two sovereigns who are clashing with each other. Military cooperation is a government-to-government relationship. Unfortunately, the reward for all of the tribes following that was to follow through on Georgia in particular. Georgia pushed aggressively to get these tribes removed from this area. For anyone who studies U.S. constitutional history, Georgia would only ratify the U.S. Constitution on the federal promise to remove the indigenous populations of this part of the world. So when the removal came to be, largely through state coercion and federal ambivalence, if not complicity, it was fulfilling a promise made to the state of Georgia. And then each of these tribes ultimately were marched, boated, rode horses, took trains, steamboats, ended up in Indian territory, and an area now called Oklahoma. So the first removal occurred in the 1830s, 1840s. Right after getting to Indian territory, the U.S. Civil War breaks out, and much of that was fought in the Indian territory. So immediately upon arrival, there's warfare. There's also epic drought. After the Civil War, the U.S. coerced a new set of treaties, and they opened the lands of the tribes in Oklahoma, then Indian territory, to the railroads. After 1866, you started having railroads bisecting the treaty homelands that had been promised to the tribes in compensation for their Aboriginal homelands. And with those railroads came hordes of non-natives. And within 10, 15 years, the tribal citizens were minorities within their own lands. And as soon as that was the case, politics being what they are, agitation began. And the non-natives who settled in Indian territory organized for the state of Oklahoma to enter as the 46th state in the Union. That history is very real. And anyone want to go spend a couple weeks in Oklahoma, you'll see it's also very current. There's still a lot of the residuals of this history that are still being battled out in the courts. They're battled out in the politics every day. And it induces within the tribal advocate and tribal leadership community a sense of urgent protection of what tribes have. Second Chief Beaver made the comment earlier. I think Deputy Chief Warner made the same comment. The job of a tribal leader is to protect sovereignty. And that is not just a buzz phrase. That is a remarkably challenging proposition. What does that mean? What does that mean in a complex environment where most of your neighbors now are not citizens of your tribe, where most of the land has traveled out of the hands of the tribal government? The people still exist, but the legal context in which they exist has been radically altered because of circumstances that were outside of tribal control. Another aspect of history that is completely relevant to where we are, Chief John Ross was the head of the Cherokee Nation during removal. And he was a staunch opponent to removal for as long as he could. The state of Georgia used its laws. It basically outlawed being a tribal official. It was a violation of state law to be a Creek or Cherokee official. Any non-Indian who wanted to do business within either of those tribes' lands had to swear a loyalty oath to the state of Georgia, so on and so forth. And it was part of using the legal system to coerce the tribes to giving up. And it combined with Atlanta as the beachhead, a massive onslaught of non-natives moving in on tribal lands. That was a decision point for how to handle it. Chief Ross made the historic decision to go to court. And it's interesting to put yourself in his position back in the 1830s. No tribe had done that before. That was the US court system. The tribes were considered essentially foreign nations at that time. So why would a tribe seek relief within the legal system? Because he believed in the law. He was a highly educated, highly successful guy who looked at the world around him and said, law is now shaping everything. So the Cherokee Nation went to the U.S. Supreme Court and sued the state of Georgia. And that resulted in a landmark decision, Cherokee Nation versus Georgia, easy to remember. And I believe it was 1832. I'm going to sketch that later. The Supreme Court closed the doors to the nation based on some legal gymnastics, basically said, you know, the Cherokee Nation couldn't go to the Supreme Court with these complaints against the state of Georgia. But in doing so, the court excoriated the state of Georgia. That ruling makes for wonderful reading if you're interested in this history, as far as the lengths that the state went to try to exterminate the tribes. In denying the tribe access to the legal system, though, the court also just kind of riffed a bunch. It's called dicta, but it's basically the intellectual musings of the court. And it sat there and is like, what is a tribe? And the court went through the history of colonization of this nation, the treaties, the dealings between tribes and the European colonial powers, how Congress had dealt with the tribes, and it came to a very clear conclusion. The Cherokee Nation is a sovereign. It is a polity that's made up of a distinct people that have the fundamental right to self-determine, which is at the heart of sovereignty, is self-determination as a community. It then closed the doors and left the Cherokee to their fate. A couple of years later, Cherokee regrouped. They found someone who would satisfy the court's test, and the theory won. The state of Georgia was acting illegally. No one's ever been able to track down whether he said it, but it's generally credited to President Jackson, saying, well, the court has made its decision, let's see it enforce it. And removal continued apace after the court victory. So here you had Chief Ross making, I think, a hopeful act of going into court as a sovereign, saying we're entitled to certain rights under our treaties, we're entitled to certain treatment, and pushed until they got the court to agree with them, and it still didn't matter. Removal still occurred. But Chief Ross also used, the Cherokee Nation at that time published its own newspaper, and it was very active in kind of the culture scene in New York and DC in making sure folks understood what was happening here. And the treatment of the Cherokee Nation at that time became a national issue on par with like debates about the border today. And it was seen as something that would characterize the nation, the United States, forevermore. Those are the roots of tribal sovereignty, not as an idea, but as a legal doctrine. Since what they're referred to as the Marshall Trilogy, there's three rulings that were orchestrated by Chief Justice John Marshall, the first Chief Justice of the U.S. Supreme Court. And they lay down kind of the basic foundations of federal Indian law. And I'll hit just the highlights on it, but one, tribes are sovereign. They are a polity that pre-exist the United States Constitution. They do not derive any power from the United States, but they derive their power from their own existence, just like any other nation. There is a government-to-government relationship that is primarily, if not exclusively, tribal federal. Of course, tribes have government-to-government relations with states and other governments, but there's a special relationship with the federal government, and it includes what's referred to as the trust responsibility. The courts over the generations have looked at how the United States has treated Native populations, how many treaties have been violated, how many unilateral acts have been done to injure tribal interests. And the court, as a matter of just legal doctrine, says, you know, of course, we're not going to challenge that the United States has this power, because as John Marshall referred to it in his first decision in the trilogy, these are the courts of the conqueror. You know, my paycheck says U.S. Treasury on it. I can't exactly turn around and bite the hand that feeds me. So I can only do so much as an officer of the court system. But over time, they recognize with that power came a responsibility. And in the exercise of that, of what's referred to as plenary authority in Indian affairs that resides in Congress, the United States has legal not just moral, legal obligations that are articulated in case law and statute as far as how they deal with tribes and tribal sovereigns. And as I already noted, the core element of day-to-day tribal sovereignty is the right to self-determine. And that's something, especially for federal employees, really kind of meditate on that. What does self-determination mean? And what does self-determination mean as an individual versus as a community, and as a community that's endeavoring to hang together? When we talk about kind of the law that applies to sovereignty generally here in the US, we kind of have to break it down into a couple different levels. Tribal sovereignty is no different from the principles that apply in international context. The biggest difference is that there's no supervising legal authority to enforce the rules of international norms and practices of international relations. That comes down to war or treaties, back to the case prior to removal. But the language of sovereignty is basically presumes that the sovereign is the chief, is the big dog within some subject matter area or geographic area. In the United States, everyone likes to talk about cooperative federalism, and they talk about the bifurcated system of federal and state governments. That's true. That's what the Constitution kind of mostly does, is manage the relationship between the federal government, the state government, and then deal with government individuals. But the Constitution also speaks to tribes. When you contrast the Articles of Confederation that preceded the Constitution with the Constitution itself, it's explicit. Congress is the one who has authority in Indian affairs, not the states. And that through the treaty power, the executive branch has exercised a substantial amount of power, but the states have no authority. And those are the rules that have generally been applied. The federal-state relationship is framed by the US Constitution. The federal government derives its power from all the states that agreed, so it's going to delegate it up. And it's the predominant authority with regard to the subject matters of international relations, and then certain enumerated powers. The states are seen as having this organic sovereignty, something that exists because they're there. But their powers too are limited. By joining the Constitution, by joining the United States, they recognize the supremacy of federal law, including the specific enumeration of federal authority with regard to tribal affairs. And they also limit themselves through their own state constitutions and codes. Tribes, like states, have that organic sovereignty. It's not, there's a misperception I often encounter dealing with kind of opposing counsel. The federal government has never given the tribes anything, it's only taken it away. And the tribes' organic sovereignty was whole and complete, but it's been whittled away through the federal government's malevolence and inaction are the two great pillars there. Congress has a plenary authority and has exercised it robustly. I'll get into that in a bit, but all of it ejects the state. And that's where I think you're also going to find sensitivity from tribal leaders when they turn to their federal agency, and the federal agency is prioritizing working with states, and then tribes become something of an afterthought. The tribes are the ones that have the government to government relationship. The feds have the trust responsibility to the tribes. The states obviously have a compact in the United States, no one's excluding them, but the tribes can't turn to the states and work with them in the same way that they have to work with their federal trustee. And so those, when you hear from the leaders, they've got to go back to their constituents in their communities. That's the conversation that's happening when they fly back home. I almost nerded out and started bringing up a law review article that I really like, but I forgot I wasn't talking to a bunch of lawyers. But the key to understanding the difference between the federal state and the federal tribal relationship, all of the rules for the federal state relationship are laid out in the Constitution. They were a pact, an agreement. For the tribes, it wasn't so much. It's really been through the power of colonialism. And colonialism is kind of a vogue word in the academy right now, so on and so forth. And I'm talking about it in the raw sense of the colonization of the lands that were Georgia to create the state of Georgia. And that is a more amorphous, softer kind of body of law because it changes. And when there are fights, tribes have to go into other sovereigns' courts to essentially have their own sovereignty weighed and measured, which is a difficult proposition. It's not a proposition that the states or the federal government ever have to face. Forget about the law. I already touched on this, but sovereignty is kind of also become a word like freedom or liberty. You know, everyone's for it. Three blind men and an elephant, though, can't agree on what it looks like. It's a term that's often invoked more for its rhetorical value than its tangible legal value. Strip everything else away. Sovereignty is about a socially coherent political collective. And every tribe I've had the honor to work with, one of the first things I always try to do is just learn the tribe's history. And it's looking particularly at the intergovernmental relations, because that's where I work. And it's always the same story. And I always take away from that just kind of being stunned that the tribe's still there. And the fact that the federal and state systems have thrown so much at these tribal governments, and this social collective has continued to cohere and to continue to hold on to that sovereignty and to provide for itself, being its citizens, is a remarkable story. And it's something that when working with the federal trustee, I think has, and this would be more of a moral, not a legal obligation, but some obligation to sit down and familiarize yourself with those stories as well, the treaties, the statutes Congress enacted to deal with those tribes, and to familiarize yourself both with the nuances and details of that relationship, and then how that interrelates to the programs that you're administering. Because it might seem far removed, but it's not. There's a straight line that connects kind of that history and relationship through the programs that are operated today. While the language of sovereignty can kind of get broad, it's still the language we use for intergovernmental relations. And in a high functioning dynamic, you're going to see a lot of substantive relational respect, not just the shibboleth of kind of nodding to consultation or nodding to, yes, there's a special relationship, but a dynamic living relationship that is really between and among actors who are trying to pull in the same direction. And if they're going to start pulling at cross purposes, they'll sit down and figure it out. But it's pluralistic. It recognizes the separation between communities while making room for common interests. When it's poorly functioning, see Oklahoma, it gets abusive, and there's a denialism, or there's acting on ignorance or thinking, it's really not that important. And sometimes that dysfunction can be passive through not really dealing with the complexity of the issue. It's not easy. It's hard, but we'll get to the motivation for why you need to do it anyway. So beat some of these points already. Next slide, I'm going to give you a quick crash course in the history of federal Indian policy. I'm going to just jump to that. But bottom line is, the U.S. has changed its mind a lot in how it wants to deal with tribes. And it's not figuring out a coherent policy from day one to day now, has had consequence. And it has created a remarkably complex legal landscape that, whether we recognize it or not, we navigate every day. The tribes are aware of it. They've got to deal with it every day. The trustee isn't always, and the states certainly aren't. But we've got to kind of move through it. If we're going to have an effective government-to-government relationship, we've got to deal with kind of the complexity that the tribes are having to deal with. Just to simplify this, here's a non-scientific through line. But these are the major policy eras of federal policy and dealing with tribes. I won't go into the details of each policy era. You can Google it. You can find a good summary. Bottom line is that the federal government has vacillated between working with tribes as tribes versus working with Indians as individuals. And whenever the United States has opted to bypass or disregard the institutional structure that a tribe has organized for its own affairs, it has gone poorly for tribes. The loss of lands occurred through allotment and assimilation, through termination, through the Indian Wars of the John Wayne era. That is what seems to be what most people are familiar with when they think of American Indians. The legacy of those failed policies was the decimation of tribal populations, the expropriation of tribal wealth, and the imposition of disabilities on tribal peoples within the legal system to protect their own interests. Major turnaround in that came starting in 1968, where not out of any generosity of spirit, but the United States looked at the long history of its failures and said, we got to change course. And it started, and as a good yellow dog Democrat from Massachusetts, it pains me to say this, but Richard Nixon really was the one who first started turning that around by working with Taos Pueblo to return sacred lands that had been taken away by administrative fiat. And then by declaring an end to the termination era and declaring that henceforth, the United States was going to work on a government-to-government basis with tribal nations. That kicked off kind of a renaissance in DC. It led to the self-determination legislation in 1975 that first dealt with education, housing, healthcare, and it authorized federal agencies, if they were operating a program, the primary beneficiary of which was a native population, to turn that program over to the tribes. And the tribal health systems that most tribes have now come through the takeover of federal programs to provide health benefits, health services to native populations. And experience has been, tribes have done a heck of a lot better job than the federal government ever did. And success built upon success. Professor Joe Kalt, he's an economist with Harvard, and he recently published an article. He looked through and he was trying to determine what the policy impact has been from the self-determination era. And controlling for things like gaming, controlling for things like location and all the rest of that. There is one single factor that has led to increased tribal incomes, tribal health outcomes, tribal education, and that is federal self-determination policies, getting out of the way and then supporting a tribe to provide for its own. It has good policy impacts, and it is not even a close question. So that self-determination era, that government to government relationship, bring that back to the fore, has been the one thing that has allowed tribes to kind of no longer have to constantly be shielding themselves from abuses from the federal trustee, and instead focus on getting the work done on behalf of their tribal peoples. Your director is going to be going out to Chickasaw. We were talking about it over at lunch. The list of stuff we want to show her is pretty long. And I think it will blow her away, from senior housing to education to after school programs to daycares it is far and wide. And it's not just for the tribe. The tribal investments in a context like Oklahoma spill over into investing into non-tribal stuff. Each of these tribes are building schools, water and wastewater systems, not just to benefit a tribal population, but to benefit these communities. And guess what? They're doing it without a tax base. They're doing it through ingenuity, working with federal programs, economic development to create resources to then invest in their own homeland in the future. So let's shift and talk about kind of some examples of relations across the sovereign line. This gentleman, he was named Ishi, which he was the last surviving of the Yahi of the tribe in California. And he showed up out of the woods in 1911 out there in California, and he instantly became kind of a national figure. He became an object of study. He was considered the quote, last real Indian wandering out of the woods. He was essentially adopted by some anthropologists. He lived in the University of California Hospital and Museum, and he was put on display. He died 5 years after he emerged from those woods. He's not really well known. That building, that's the museum building that he lived in. He was a human being who was simply converted into an object of study. I'm going to mispronounce this name, but the Borezg report, 1977. The U.S. Comptroller completed a study based on complaints and was looking at federal health programs and health services and their interaction with tribal populations. The use of Indian boarding school kids to test drugs for different treatments without any parental consent. And the federal position at that time was, we don't need to talk to the parents. We're the guardian for these kids. We get to make the decisions for everybody involved. Complete objectification and dehumanization of those children. And that was in the 70s. More problematic. IHS's forced sterilization or unconsented sterilization of Native women of child-bearing years without any real evidence or work on consent. Now we're in the 70s. I'm willing to wager the majority of the people in this room, I probably shouldn't say this, I'm going to offend some people, but at least half the people in this room were probably alive in the 70s. So now we're talking about stuff that's occurred within living memory within this room. And so when the feds show up to talk about healthcare issues, there's an experience of abuse and objectification that the feds have some obligation to recognize and figure a way past and through. There are folks on the other side of the conversation that want to work with you, but they also want you to know the story and to respect what's happened, because when they go back to their constituents are gonna be remembering these stories as well. Those were real abuses, and they're not ancient history. Governor Noem up in South Dakota during the COVID outbreak, tribe shuts down checkpoints on the highways because they're trying to protect their elders. COVID was spreading through the community and they were trying to limit the introduction of the virus. What does the state governor do? She turns it into a political theater event and attacks the tribe for its public health measures. This goes on today in Oklahoma. It's a constant fight. And oftentimes the tribes will look around and be like, where's our trustee? We need you to back us up here. We need you to come in here and recognize the seriousness of the programs we're trying to operate and the shared policy goals of keeping people healthy. Positive examples. There's a tendency and with good reason, but to focus on the victimry aspect of America's treatment of indigenous peoples. But like I said, when the tribes are still here, and not only that, they're doing a hell of a lot. Many of you, I hope, are familiar with the IHS Chickasaw Nation joint venture to build an 80-bed hospital in Ada, Oklahoma. It is the premier healthcare facility anywhere in Southeast Oklahoma. I can say that because Choctaw's not here. No, just kidding. It serves as the Indian Health Service facility for all Native folks living in Southeast Oklahoma. We're now building another hospital, even bigger one, out in Newcastle, also in partnership with the feds. This is what should be. This is the stuff we should be doing, figuring out ways to leverage kind of tribal expertise, federal expertise, and resources to partner to expand services to these populations. Cherokee Nation and OSU creating a medical school that is specifically serving tribal folks to go out and provide healthcare in tribal communities. This is purely anecdotal on my part, but I went to a dinner the other night and I met a whole bunch of kids at UNC. They're all Native kids. And about 3/4 of them were going into public health. And it struck me that it was part of the legacy of COVID. These were kids who saw what their tribe was doing for their community. And they were like, huh, public health is cool. I want to do this. I want to give back. And I was really happy after this dinner. And stuff like this, building the tribal bandwidth for these types of professions creates hope and opportunity for the next generation of folks who are coming up and eases the workload for the feds. If you look at this over a long arc, the feds have a very clear interest in tribes being able to take care of their own, and so do the states. So when we're able to get the bureaucracy and the politics out of the way, there's no end of the kind of partnerships we can form. Somebody, and it might have been Dr. Cohen, but in Oklahoma, we had a COVID denying state governor who seemed intent on erecting barriers for folks to get access to vaccines. The tribes led on that. The tribes were the one who leveraged their access to getting vaccine doses and opened it up to everyone. I don't know if I'm going to be able to read this. I have to read it off here. My eyes are getting bad. But this is a tweet I'm just going to read it. I just got a vaccine appointment with the Chickasaw Nation, who is now vaccinating any educator in Oklahoma. I am so overwhelmed with the historical weight of a removed Native nation providing this settler with a life-saving vaccine. And as of the time I took this screen cap, that was retweeted 3,842 times. And Chickasaw wasn't the only one doing it. We all were. And the latest example, maybe not purely in the public health space, but a number of states have rejected the summer food program for at-risk kids. The Osage Nation, Muskogee Creek Nation, Choctaw Nation, Cherokee Nation, Chickasaw Nation have now all stepped in and, working with their federal partners, are keeping that program available for hundreds of thousands, if not millions of kids throughout Oklahoma. So when federal agencies are looking at their mission, their program, the politics between the federal and state governments can often get in the way. But the tribes are invested in their own continuance, their own communities, their own survival, and make excellent partners. The figuring out, and I commend CDC for convening this TAC, the one acronym I feel confident of after this morning. But we need more of it, a lot more of it. And we need patience, and we need commitment and engagement. And only good things will come of it. So just some closing thoughts. Bottom line is, sovereignty is, and government to government stuff isn't about generosity. It's not about magnanimity on the part of the United States. It's the law. And tribes have spent generations fighting, ever since John Ross went to the US Supreme Court, to have the law stand up and protect the rights that the tribes are entitled to under this federal system that they didn't choose, but is here. They fully participate in it now. No one's trying to roll the clock back, but it's the law. And when you really look at it, when the feds work within that system, you get better results. And again, it's not even a close question. It improves all of our outcomes. So I have to, my last comment is, it feels so strange making these comments when I'm staring at tribal leaders. I'm not talking to you. But I really appreciated the opportunity and invitation to come out here and visit and to let me ramble on it about this subject. It's critical.
Thank you so much. Thank you, Stephen. Even though there are many tribal leaders in this room, there are some who are not. And that was our goal, was to share tribal history, share tribal position, and to help our agency partners understand what it means when we're talking about government to government relations. And so thank you. You actually did a wonderful job. As tribal leaders, we still learn new things, every day. And so I just want to thank you once again for being here and for doing this presentation. So once again, thank you, Stephen.
Are there any immediate comments from TAC members or CDC leadership? Yes, Dr. Dolphin.
Thank you, Deputy Chief, and thank you, Legislator Barker. I just want to say on behalf of CDC and our Public Health Infrastructure Center, we really, really appreciate that fantastic presentation. So I'm sorry I could not be there with you in person, but I did want to say it was a fantastic presentation and we really appreciate it. Thank you.
Thank you, Dr. Dolphin. Anyone else? Well, I know we've got time to let this marinate and let it soak in, as we like to say. And many of these stories, this is just one area of Indian country. Understand that to the CDC leadership. There's tribes represented all over the United States, and each one of them have a story, much like this, some very similar, some very different, but yet the outcomes have all been the same. So I know, Connie, I said I don't know that we need a break, but I think if we would take a 10-minute break at this time and come right back because we have one more presentation. But before we go on break, I just wanted to again thank Stephen Greetham. Thank you, sir. Always a pleasure. You're a fine gentleman, sir. Very much appreciated.